who joined us through and everyone who has joined us through the YouTube live for the final round of 9th National University Bose and Mitra and Company International Maritime Arbitration Moot 2022. I congratulate both the teams who have successfully completed their voyage to the finals of the moot, passing through the wavy seas of 4 preliminary rounds, a quarter-final, and the semi-final round. Before we proceed with the proceedings, the organizing committee of IMA would like to present a brief video on the case study of the moot so that everyone gets a gist of the case before proceeding begin before the tribunal today.
Welcome to this edition of the International Maritime Arbitration Moot. Watch this video to learn more about the case and the issues that the teams will be dealing with. Welcome to this edition of the International Maritime Arbitration Moot. Watch this video to learn more about the case and the issues that the teams will be dealing with. Let's first look at the facts. In the present instance, there are 3 parties involved: Caspian Traders Limited, hereinafter referred to as Caspian, Tawe Limited, hereinafter referred to as Tawe, and Armadorus Cruise SA, hereinafter referred to as Cruise. Caspian was the party shipping 20 hydrogen fuel cell converters, each costing $30,000 per unit. The shipment was to be delivered from Santos to Chennai through the MV Odysseus, owned by Tawe. A bill of lading was issued on the Combicon 2016 form. However, the bill did not mention the value of the goods. The goods were shipped on 25th November 2020. Certain additional clauses were made in the bill, specifically subjecting the bill to the English law, with all disputes to be settled through arbitration in SCMA in Singapore. Further, the clause provided that any and all liability in the carrier shall cease once the goods are discharged from the Odysseus. The clauses also mention the carrier to be liable to only $500 per unit in case of loss or damage. Lastly, the bill of lading was subjected to the Hague Rules, and the 11th clause of the Combicon bill was removed. On the 1st of December, the Odysseus arrived at Cartagena, Colombia. Tawe discharged its cargo and transshipped it to the Hidalgo owned by Cruise. Tawe received a bill of lading by Cruise, which was also based on the 2016 Combicon bill form. This bill did not mention the value of the goods as well. The port of shipment for this bill was Cartagena, and Chennai was the port of discharge. Tawe was assigned as the shipper and consignee. This bill contained certain additional addendums as well. Firstly, it subjected the bill to English law and disputes to be settled by the SCMA in Singapore. Secondly, it deleted Clause 11 of the Combicon bill form. Under the Paramount Clause, the bill was subjected to the Hague Rules 1924. However, it did not seek to apply Article 9 of the said rules. Lastly, the clause limited the carrier's liability for any loss or damage whatsoever to a sum of £1,000 per unit. During the voyage between Cartagena and Chennai, the vessel encountered a hurricane and the stow collapsed, which resulted in the cargo being lost. The loss was admittedly to Cruise's lack of due diligence, resulting in failure to correct a fault in the vessel's weather radar before departure from Cartagena. Caspian issued a claim for arbitration against Tawe and Cruise. In both proceedings, Caspian claimed $600,000 for the loss of the converters, a figure which was claimed to represent their market value. Thus, the major issues for consideration under the present case are: firstly, the liability of Tawe and Cruise for the loss of the converters. Secondly, the quantum of damages if liability was so accrued between the parties for the loss. And lastly, on the composition of the arbitral tribunal. In this edition, we look to host you all in an event larger in scale than previous editions and eagerly await all participants, judges, and audiences.
Thank you, everyone. I will now request everyone to leave the auditorium by clicking the back button of their browsers and join the main courtroom so that we can begin with the final round. arbitrators are ready. Before starting, I would like to confirm with my live logging team if we are live on YouTube. Hello everyone. I again welcome you to the final round of the 9th National University Odisha Bose and Mitra and Company International Maritime Arbitration Moot. Before we proceed, I would first introduce the panel of arbitrators we have for the finals of the moot. I would like to introduce Mr. Amitabh Mazumdar, who is a managing partner of India's leading maritime firm, Bose and Mitra and Company. Amitabh sir has been a source of inspiration for us for the years of hosting this moot court competition. And through his support, this moot has now become a premier maritime law. Introducing our next judge is Professor Simon Borgen. Professor Borgen is a professor of maritime law at the Swansea University. I would also like to introduce Professor Andrew Tattenbaum. Professor Tattenbaum is the chair in law of shipping and trade at the Institute of Shipping and Trade Law, Swansea University. Next, we have Mr. Ian Teo. Mr. Teo is the managing director and one of the founding directors of the Hillsman LLC, Singapore. We are here today in the matter of an arbitration between Caspian Traders Limited and Tawai Limited and Armstrong Cruise SE. The claimant, Caspian Traders Limited, is being represented by the team of School of Excellence in Law, Dr. Ambedkar University, Tamil Nadu, and the defendants, Tawai Limited and Armadros Cruise SE, is being represented by the team of Gujarat National Law University, Gandhinagar. The proceedings of tribunal may start.
Very good afternoon. Before I begin, I just wanted to check if I'm audible and visible enough. Thank you. A very good afternoon and greetings to the panel of arbitrators. Myself, S. Shweta, I'm here as counsel number 1, along with my co-counsels Sonu Mehta and Tanvi Kankaria, representing the counsel for the claimants in the arbitral claim of Caspian Traders Limited and Tawai Limited as the first defendant and Cruise SA as the second defendant. Before moving into the facts in hand, I would like to state that the reason for filing this arbitral claim is that Caspian Traders has suffered immense loss due to trusting and giving the goods in good faith to Tawai and Cruise to transship the goods to Chennai. However, due to the negligence and maintenance of an unseaworthy vessel of Cruise and Tawai, we have suffered immense losses, and due to which we have approached this arbitral panel for the concerned damages. In order to explain the facts in hand, I request the arbitral panel to please refer to the detailed timeline given to the arbitral panel by page number 1 of the compendium submitted on behalf of the claimants. If you may please refer to page number 1 of the compendium.
I'm afraid I might have a problem in doing that because if I certainly won't be able to see you if I look at another.
I have it because I can watch it because I have a second computer.
Right. So respondents.
If you have the compendium in hand, sir, it would be convenient for the facts to be understood even clearly because we have a timeline explaining the details of the facts.
Right, I've got the compendium up here. I can't see you at the moment. I can hear you, so I'll.
We are fairly familiar with the facts, so perhaps you could limit yourself to any particular observations you have to make about them.
Yes, sir. I would like to just state 2 to 3 facts, important facts in this present case. That number 1 is that Caspian Traders Limited contracted Tawai Limited for the transport of 20 hydrogen fuel cell converters from Brazil to Chennai, and a bill of lading of communicant form was entered into between the two. Further, the goods were transshipped from the Odysseus ship to the Hidalgo ship in the Cartagena port owned by Cruise SA Limited, also in the communicant bill form. However, during the voyage between Cartagena and Chennai, there occurred a hurricane, and also it was due to the non-maintenance of a seaworthy vessel by Cruise SA that our goods got lost, and due to which we have suffered $600,000 as damages, and for the same we have approached the arbitral panel, sir. If the arbitral panel doesn't have any doubts to the facts in hand, may I please move on to my issues?
Of course.
Yeah.
Thank you, sir. The first issue in hand is that the arbitral panel shall consist of 3 arbitrators. It is most humbly submitted before this arbitral panel that the intent of the party in this present case, which is mutual, wanted to apply SCMA arbitration rules in this present matter. Sir Arbitrator, the party autonomy and express agreement by the parties to incorporate SCMA arbitration rules is evident from, if you may please read, clause 1 of the addendum of the bill of lading given in the case study itself of both Odysseus bill of lading and Hidalgo bill of lading. If I may please ask my researcher to paste the concerned provisions to the arbitral panel in the chat box. If it is for convenience purposes, may I ask my researcher to publish that? Thank you, sir. I would ask my researcher to publish the same. The clause 1 of the addendum reads as follows: that the bill of lading is subject to English law, and any disputes arising out of or in connection with it shall be settled by SCMA arbitration in Singapore. So, the panel of arbitrators, the parties agreeing to SCMA as an institution for arbitration, is in itself is a proof that they wanted to invoke SCMA arbitration rules to apply in this present case, which thus makes SCMA arbitration rules as the curial law. If the SCMA arbitration rules are the curial law, Rule 8.2 shall apply in this present case, where Rule 8.2 shall read as follows: where the parties have not agreed on the number of arbitrators but have agreed onto these rules, 3 arbitrators shall be appointed. Sir, in this case, as the parties have not agreed to the number of arbitrators, but however have agreed to the rules, which is SCMA rules, they shall be 3 arbitrators appointed in this present case. However, an argument that may be posted from the learned counsel of the defendants is that Rule 32 of the same rule shall apply in this present case. However, Rule 32 states that the seat of arbitration shall be Singapore unless otherwise agreed by the parties, and where seat of the arbitration is Singapore, the International Arbitration Act shall apply. However, sir arbitrator, I would beg to differ in this present case that IAA is not the curial law and is just the law governing the arbitration, and that curial law will have the force of law in the procedural matters in hand, and thus 8.2 shall apply in this present case without any doubt. Further, I would like to submit that SCMA Rule 8.2 cannot be proved to be inconsistent with the International Arbitration Act rules. So before we get into the fact whether IAA Section 9 provision, which states that 1 arbitrator shall be appointed, is mandatory or not, I would like to state that it should be first, there should be an inconsistency in the provisions before we get into the mandatoriness matter in itself, sir. Sir, for the same, I would like to state that if at all the seat of Singapore is given importance and IAA is governing this case, I would request the arbitral panel to please refer to Section 15A, Clause 1 of the IAA, which states that, if I may read for the panel of arbitrators, that to avoid apologies, to avoid doubt, it is declared that a provision of the rules of arbitration agreed to or adopted by the parties, whether before or after the commencement of the arbitration, applies and is given effect to the extent that the provision is not inconsistent with the provision of the model law or this part from which the parties cannot derogate. However, in this case, there has to be an inconsistency to get into the matter of being it mandatory or not. Along with Section 15A Clause 1, I would request the panel to please read Section 15A Clause 5, which may read as follows, that which Section 15A Clause 5 deals with whether in what circumstances the said provision is not inconsistent with the IAA. 15A Clause 5 states as follows, that a provision of rules of arbitration is not inconsistent with the model law or this part of the law merely because it provides for a matter which is covered by a provision of the model law or this part, which allows the parties to make their own arrangements by agreement, but which applies in the absence of such agreement. In this case, sir, just because they have agreed to a rule which and agreed to the rule which also deals with a similar provision of Section 9 doesn't make the whole provision inconsistent per se, and the same has also been held in certain judgments such as Bank Millet versus Helleniki Techniki. In page number 4 of the judgment of the 1984, it states that a similar case has been a similar case, however, different rules are followed, where the ICC rules and the Arbitration Act of 1996 are in conflict with each other is what the issue is in hand. And it was held that the ICC rules will apply ipso facto to law as the parties agreed to it, just like how the parties agreed to the SCMA arbitration rules. And it is also pertinent to note that the ICC Rule 8 of the same is very, very similar to Rule 8.2 of the SCMA arbitration rules. And thus, my submission is that according to the SCMA arbitration rules, 3 arbitrators shall be appointed. And as there's no inconsistency in the present case, there is no need to get into the International Arbitration Act in itself, and SCMA rules shall prevail. If I may answer any of the queries that has been posted in the first issue.
Well, I have one slight worry. If you are right, and you may be or may not be, but if you are right, the relevant provision of the Singapore International Arbitration Act begins to look a little like Cinderella, all dressed up with nowhere to go. That is not having much effect. I don't know whether you have an answer to that.
Indeed, sir. We are not saying that it doesn't apply in this present case because it is not prevalent. But however, we would like to state that there is an intention of the parties to apply SCMA arbitration rules. And we have to give importance to party autonomy per se, sir, even before considering Section 9 of the International Arbitration Act to apply in this present case. And as the party's intention was mutually to agree to SCMA arbitration rules, there is no per se to apply IAA in this present case, sir.
Thank you.
Thank you, sir. If there is no further questions, may I please move on to my issue number 2? Thank you, sir. If I take a moment, if I may take a moment, issue number 2 deals with the merits of the case, where TAVE is liable for breach of contractual duty. It is most humbly submitted before this arbitral panel that TAVE is liable for breach of contractual duty, and the same shall be submitted by myself in 2 sub-issues, where the first sub-issue deals with Hague rules will apply in this present case over and above the provisions of the contract, and the same shall be proved as follows. The panel of arbitrators for the same, I would request the panel to please refer to clause 4 of the addendum of the Odysseus Bill of Lading mentioned in para number 3, if you may please.
Right.
This reads as follows, that the contract contained in or evidenced by this Bill of Lading is subject to the Hague rules. In this case, the panel of arbitrators, Hague rules here means Hague Rules 1924. And as you may read the wordings, it states that the contract contained in or evidenced by this Bill of Lading is subject to Hague rules, which gives it a clause paramountcy effect. as I may say. And if to introduce the clause paramountcy, I would like to state that they state that when a clause paramount effect is given to Hague Rules 1924 in this present case, the clause paramountcy incorporates Hague Rules over and above the contract. Hague Rules or Hague Bose rules agreed by the parties, when agreed in clause paramountcy, will be given the force of law once incorporated in the contract. Though I am aware of the fact that neither Brazil nor Colombia is a party to the Hague Rules 1924. However, applying clause paramountcy in this present case, which has been applied by many states who are also not a contracting state per se, have applied clause paramountcy effect to Hague Rules, and that effect per se would give the Hague Rules the force of law and not just as a mere terms of contract.
If I can come back to you there with, again, I suspect a stupid question. If you look at the Carriage of Goods by Sea Act 1971 of England, that says that the Hague Rules have the force of law if either the port of shipment or the place of the issue of the bill of lading is a contracting state. Are you not inviting the arbitrators to extend and greatly extend the effect of the Carriage of Goods by Sea Act 1971?
Sure, sir. But however, in this case, as the wording clearly states that we would apply Hague Rules, and our first intention here is to apply the Hague Rules 1924 and not the Bisbee rules per se. But however, as an arguendo, we would also like to state that according to English law and the incorporation of Cox in 1971, just because we have incorporated English law, we would also be able to incorporate Hague Bisbee rules. But however, according to clause 4 of the addendum, we would stick to the point that we are incorporating Hague Rules 1924, giving it clause paramountcy effect in this present case.
Can I just ask a follow-up question, counsel? You talk about force of law. How can the Hague Rules ever have force of law in a contract which is subject to English law? I mean, I can see possibly that you may be making an argument based on the contractual construction of that mode of incorporation, but perhaps you could clarify, because I think you obviously want to get rid of, you want to Article 3, Rule 8 to become your friend and start knocking out various clauses. So perhaps you could explain a bit more about what is the contractual process by which this incorporation of the Hague Rules has paramount effect.
Indeed, sir. I would like to state a case law, a precedent in this matter. However, I might know that this is not binding per se in an arbitral tribunal, but for precedence purpose, I would like to state the case of Sabah Floor and Feed Mills versus Confess Company Limited. It clearly states that even if the Hague Rules is incorporated through contract, they have the force of law, and without any express deletion per se, Hague Rules will have a full operation of law. In this case, as clause 4 reads, Hague Rules is incorporated and they have not deleted any particular article of the Hague Rules in the addendum itself, thus making the whole of the Hague Rules applicable to the contract. And when the whole of the Hague Rules apply to the contract, it will have a force of law because of the power given to clause paramountcy in this present case. And as there's no partial deletion also in this present case, the whole of Hague Rules will be applicable. If that answers your question, sir.
So what was the actual finding in Sabah about the effect of the incorporation of the Hague Rules? Did the English court say that they had the force of law, or did the English court say that Article 3, Rule 8 applied as a matter of contractual construction? What was the actual result in that case?
Sir, the same regarding Article 3, Rule 8 will be dealt by myself right now, sir, after the same. That okay. the Article 3 Rule 8 will have effect in this present case. That because, as I've already proved, that Hague Visby rules once incorporated will have a force of law. I would like
I must
to
just correct you, counsel. Hague rules or Hague Visby rules?
Hague rules 1924, sir. Apologies
Thank
for
you.
the.
Thank you. Please go on.
Yes, sir.
Can you just provide us the paragraph in the Sabha which says this, the proposition that you're saying, that it has the force of law?
Yes, sir. Indeed, if you may give us a little more time, my researcher would get back to the paragraph number in the chat box if it is okay, sir.
Yeah.
Thank you, sir. So my second limb of the argument is that TAVE has breached the contractual duty to render a seaworthy vessel, and the same shall be dealt by myself. As I've already proved that Hague Rules 1924 shall have the force of law.
Just before proceeding, counsel, I just wanted some clarity on fact. Was this a deck cargo? Because somewhere along the lines in the facts you say that the cargo collapsed and then was lost. So I take it that this was a deck cargo, or was it under deck cargo?
Sir, it was situated in the store, sir. Inside the ship, the goods were actually inside the store. But however, due to the hurricane, the store collapsed, due to which the goods were lost in the sea, sir.
Yeah, but if they were lost in the sea, they must be over deck and not under deck, I would imagine. Because if they were lost in the sea under deck, that would have a huge gash and probably the whole ship would have sunk.
Or they could have been totally damaged as a result of the collapse of the stow within the vessel. I'm not sure whether that is made clear one way or another.
As the facts are silent as to where the goods were actually stored, and it is clearly stated that the store collapsed, I would rely that the store collapsed due to which the goods were lost, sir.
So when you say goods were lost, you mean goods were completely damaged as opposed to lost overboard?
I'm sorry, sir?
So when you say goods were lost, you mean goods were completely damaged as opposed to lost overboard?
According to paragraph 5 of the facts, it states that the goods were lost, sir. So in this case, the goods were actually lost per se.
Okay.
As I'm running out of time, may I please get an extra 1 or 2 minutes to sum up my last submission?
Yeah.
Yes.
Thank you, sir. I would like to please, I would like the arbitral panel to please refer to Article 1, Subclause E of the Hague Rules 1924. If I may read it for the arbitral panel, it defines the carriage of goods as the period. Carriage of goods covers the period from the time when the goods are loaded onto it until the time the goods are discharged from the ship, sir. Sir, if you may please refer to para number 3 of the case study, it clearly states that the port of loading in this case was Santos, Brazil, and the port of discharge, however, in this case is Chennai. So, according to the first bill of lading, the first bill of lading is applicable till the goods reach the actual port of discharge, which was agreed by both the parties, which is none other than port of discharge being Chennai in this present case, sir. Thus, I would like to make the submission that according to Article 3, Subclause 2, which states that subject to the provisions of Article 4, Article 4 dealing with exceptional circumstances, subject to the provision of Article 4, the carrier shall properly and carefully load, handle, stow, carry, keep care of, and discharge the goods carried. In this case, I would like to make the submission that the goods were not properly discharged because the goods were not discharged in the actual port of discharge being Chennai in this present case. Though the arbitral panel might place reliance on Clause 2 of the addendum, I may please read Clause 2 of the addendum as follows, that the carrier has liberty to transship goods on any term whatsoever, and any and all liability of the carrier, whether in contract, tort, or bailment or otherwise, shall cease once the goods are discharged from the ship of Odysseus. Sir, I think
we're going to have to tell you that time is very close to being up, if we may. We have given you indulgence, but our indulgence is not unlimited.
Yes, sir. I'll wrap it up, sir. So clause 2 of the addendum is giving wide freedom to the parties to transship the goods on any term whatsoever, and the discharge and the goods once are discharged from the ship, there's no liability attached. However, this clause 2 of the addendum is null and void according to Article 3, Rule 8. If I may please read Article 3, Rule 8.
Oh,
I don't think you need to. I think we know Article 3, Rule 8 quite well.
Yes, sir. So according to Article 3, Rule 8, when the carrier limits liability in any terms whatsoever, it is held to be null and void. And the same has been dealt in the case of the EPA judgment in the Singapore High Court, and also in the Young
Excuse me,
case.
Counsel. Hi,
Yes,
Counsel. Good evening, Counsel. Can I just follow up on the case reference? Has your researcher managed to find the reference to the force of law?
Just a minute.
In Sabah, yeah.
Yes, sir. The researcher has pasted the same in the chat box, sir. Sir, I would just take 30 seconds to wrap up my issue. I'm really sorry for the delay. If I may.
30 seconds.
Thank you, sir.
Off you go.
So, I would like to sum up my issue stating that TAWE is liable till the goods reach the actual port of discharge agreed by both the parties, and is liable for the acts of cruise as sub-bailees in this present case, because cruise has admitted to not have maintained a seaworthy vessel. Naturally, TAWE is also to be held liable under Article 3, Clause 1, Clause A of not maintaining a seaworthy vessel, as TAWE is liable until it reaches the final port of discharge. And moreover, as TAWE is the consignee in the second bill of lading, he is to be liable on the same grounds as well, sir. It was a humble arguing before this arbitral panel, and if you have any further questions, I may answer, or I may just stand down, sir.
Yeah, I was going to the chat box. I couldn't find the passage from Sabah. Which
We aren't given the passage. We are given the reference.
Right. Okay.
Without being able to sort of do a quick ILAW search. It's a bit difficult. I mean, I might try and do that, but yeah, so this is...
Could you paste paragraph 10? Do you have the word copy to paste paragraph 10 in there? If you could ask your researcher.
Yes, sir. She'll be posting it right away, sir.
That's great.
Further, my co-counsel will continue with issue number 2 and 3 as follows. Thank you so much.
And is it volume 2 Lloyd's Law report, or what is the volume 2 reference to? I'm taking it.
I think it's volume 2 of the 88 Lloyd's reports.
Yeah, I'm taking it. It doesn't say so, but.
Yes, so it is the Lloyd's Law report, sir.
Yeah, thank you.
Members of the tribunal, I hope I'm clearly audible and visible.
Yep.
Absolutely.
Yes.
Absolutely.
Very much so.
Thank you. Greetings to the members of the tribunal and to everybody who's watching. I am the second counsel, S. Sonu Mehta, and I will be dealing with the liability of the second defendant, Cruise, in the present matter, and the amount payable by both the defendants. Before I begin, I might like to place reliance on page 6 of our compendium, which is also the inner page 2, which showcases the voyage map as to how the goods actually got transferred from Santos and got lost in the middle of the voyage between Colombia and Chennai. Here, I would like to briefly explain the involvement of Cruise as the second defendant. Cruise as the second defendant was entered into a bill of lading, which was a Hidalgo bill of lading between TAWE and Cruise, wherein TAWE was named as the shipper as well as the consignee. That being the brief facts of the case that I'm going to be dealing with, I'd first of all like to confirm that everybody in this room definitely has heard of the principle no fault liability, wherein defendants are made liable even when there is no fault of theirs. But in the present case, defendants are claiming fault, like they're admitting fault, but they're claiming no liability, which raises questions and concerns before this arbitral tribunal, and I would be answering the same under 2 limbs. Firstly, was there a duty of care at all on the part of the second defendant? Secondly, if yes, are they liable to Caspian because Caspian, we agree, was not a party to the Hidalgo Bill of Lading directly or in the Bill of Lading in itself. With that, yes, Mr. Arbitrator, is there a question? I would like to continue. To satisfy this tribunal on the grounds that Caspian does have a right and follows having a remedy, I would like to place reliance on the well-founded and established principle of bailment. My first argument would be that cruise is a carrier as per the Hidalgo Bill of Lading, as stated in the facts in itself, para number 4. Therefore, the role of a carrier and a bailee are inseparable. That is, a carrier cannot begin his duty without accepting the delivery of the goods. Therefore, it is accepted that cruise had the obligation of what a bailee will have towards Tawai. And under the same circumstance, the Hague Rules also mention under Article 3.1 that it is necessary for a shipper to provide a seaworthy vessel before departure. And in the present case, a seaworthy vessel was not provided. A question might arise, what is a seaworthy vessel? There is no explicit definition or a checklist that can be filled for the same. However, a seaworthy vessel is one that is fit for a normal peril of the sea. Another question.
Can we just stop you there? I think it's admitted on all sides that the Hidalgo was unseaworthy. So I'm sure what you say is very right, but I don't think it's necessary to convince us of it.
Thank you, Mr. Arbitrator. That being the position, I would be right to say that they had a duty of obligation towards Tawai to provide a seaworthy vessel, and they violated the same. And once there is a violation of an obligation, now we come to our second question, which is, was there a violation of obligation towards Caspian? For the same, I would like to place reliance on the concept of sub-bailment and would place reliance on two definite authorities. Firstly, the case of Morris versus Martin, and secondly, the Pollock and Wright on possession. All of this
Excuse
is
me, counsel.
Yes.
I'm sorry, I'd like to interrupt with a question. I'm just curious. Don't they all owe you a contractual duty, having issued a bill of lading, naming your client as the shipper?
So they do not owe us a contractual duty because of privity coming in play. That thereby we are bringing in the concept of sub-bailment to showcase that there's no direct contractual privity between cruise and Caspian, and therefore they owe us an obligation under the terms of sub-bailment. I hope that satisfies your question. Much obliged. I would now like to place reliance on an analogy that I draw on the basis of what was given on the Pollock and Wright on possession. It was very clearly held that where there is no direct privity of contract between a third person and the first owner, when the bailee bails it by authority. If I may give an example, which is if my father bails me his car and explicitly tells me that I can bail it to anyone else on only just one condition, that should not be crashed. After I bail it to my friend on the same condition, my friend ends up crashing it. In the present case, not just is my friend liable to me, but is also liable to my father, whether or not he knows the existence of my father. For this, I would like to place reliance on the case of Awad versus Pillai, wherein it was stated that when a person takes possession of goods of another, the bailee's duty of care is owed automatically. It should not matter to that person that he may be sued by another person whose existence he is not aware of, because they anyways owed a duty of care to whoever the true owner was. At this point, I would also like to place reliance on an article written by Professor Andrew himself in the University of Cambridge Journal, wherein he gave a very good example about the fact that to say that Cruz is never liable to Caspian if he does not know of his existence is going a little too far. Because if he claims that, he can also claim that Tawai cannot sue Cruz because Tawai was not the owner. And he can also claim that Caspian cannot sue Cruz because Cruz did not know of the existence of Caspian. This way, Cruz will be going away from the responsibility of his own act, and no man should be allowed to take advantage of his own wrong, is the submission of the claimant before the tribunal today.
Counsel, could I just ask a clarificatory question? Are you talking about a duty of care in negligence? Or are you talking about a liability in bailment? Are you talking about both? Because I remember Awad and Pillai is a case, I think that there was only a duty of care in negligence and there wasn't a duty under bailment. But could you just clarify how that might apply as regards Cruz?
Absolutely, Mr. Arbitrator. I would be placing reliance on both, which is a duty of care under bailment as well as negligence under tort, which makes them liable for bailment as well as for tort. As regards to the question of whether a tortious matter is arbitrable, it is very well said that if a tortious matter arises out of an arbitration contract or consequentially of a contract, it can be arbitrated.
Thank you.
Counsel, I'm going to jump the gun a little bit here. As I understand Cruz's case, their main point of defense really is they are entitled to rely on the Himalaya clause in the contract between yourself, your clients, and Tawi. What do you have to say to that?
Surely, sir. Thank you so much for bringing me back to my own arguments. Thank you, sir. So I would go by stating that clause 11 of the Combicant Bill, my apologies, clause 15 of the Combicant Bill, which deals with the Himalaya clause, in itself under the subclause C, provides an exception, which is other than Article 3, Rule 8. So it is our contention that under Article 3, Rule 8, Himalaya clause in itself will stand to be null and void and of no effect. So the question of whether they are servant or not is not of much relevance before this Honorable Arbitral Tribunal. To prove the same, I have an authoritative judgment of the Starson case. If I may please request the Arbitral Tribunal to move to page 447 of the PDF, the compendium that we have submitted.
I think I've just rely on my memory of the Starson. I'm not. Yes. I can't switch back and forth on.
No, I will definitely brief the Arbitral Tribunal on what exactly the Starson case is about. Very similar.
This is the sort of thing. This is the page that looks like a flow chart, is it?
No, sir. This is the page where we have stated the exact para from the Starson case, which is page number 447 of the PDF, 444 of the inner page. And also the judgment is given on 465 inner page and 469 of the PDF. Wherein the judgment was by a 4:1 majority that the Himalaya clause is invalidated by the effect of Article 3, Rule 8. The judgment also said, as it's my responsibility to bring the entire judgment before this arbitral tribunal, the judgment also said that the carrier, the goods owner, cannot impose positive obligation on a servant under this concept, and we are not posing any positive obligation under the fact that they are servants, but rather under the fact that they are sub-bailies. I sense a concern, Mr. Arbitrator. Is there a question? If there are no further questions, I would like to sum up my argument by stating that firstly, Cruz is liable under sub-bailment because they owed a duty of care and they failed to take that duty of care, and they've admitted the same. So the question of that does not arise. Secondly, their immunity under Himalaya clause itself is invalidated by Article 3, Rule 8, which clearly states that any clause, covenant, or agreement in a contract of carriage relieving or lessening liability of the carrier or the shipper shall be null, void, and of no effect. A possible rebuttal might arise which says that the words ship and carrier are mentioned and not the word servant. I would like to answer to that in my arguments in itself, which is, if I may please take a moment. In the case of Starson in itself, it was held that the carrier word is wide enough to include owners of the ship as well as the ship. So the word ship was only added in order to bring out parties who are not directly a part of the contract. This was given in para 212 of the Starson case. And this was the accepted position, which is why Himalaya clause was invalidated by the application of Article 3, Rule 8. If there are no further questions about liability of cruise, I would like to move on to the amount of compensation.
Yes.
May I?
Yeah.
Thank you, panel of arbitrators. If I may please request the panel of arbitrators to move to page 12 of the PDF, as well as page 13, wherein we have clearly demarcated the amount of liability which is owed by survey and cruise and the rules that apply to the same without leaving any rule or any clause which has been deleted. Now, going by the submission of the Odysseus Bill of Lading, where there was a limitation liability clause, and we agree that there was a limitation liability clause, limited survey's liability to $500 per package or unit. But there was an additional clause later on, which read as follows. The contract contained in or evidenced by this bill of lading is subject to the Hague Rules. The interpretation of the claimants in the present case is that the addendums clause 1, 2, and 3 will also be subject to the Hague Rules because there has been no explicit exclusion. Now, yes, Mr. Arbitrator, is there a question?
Well, I was just thinking, aren't you leaving this clause, the liability shall be limited to $500 with no effect at all, if your argument is right? Because why was that clause put in if it was intended immediately to be overridden by the general clause that the Hague Rules should apply?
I would answer this on two folds, Mr. Arbitrator. Firstly, we need to understand that this addendum was signed by merchants who did not necessarily know the legal technicalities that were present in the clauses itself. Secondly, the Hague Rules, Article 4, subpara 5, does not exclude us from including a clause which gives the maximum, which gives a higher value than what is stated in Article 4, subpara 5. So given in a circumstance that the gold value drops below the amount of $500 per package, then the party would rely on clause 3, which is why we agreed to the same.
But Councillor, what do you think the parties' intention were when they agreed specifically to delete clause 11 of the Bills of Lading?
Mr. Arbitrator, I do agree that it was parties' intention, as given under clause 3, that the limit should be $500 per package or unit. However, the Hague Rules very clearly state that any clause, covenant, or agreement, regardless of what the intent was, if goes ahead and limits the liability or lessens the liability, shall be null, void, and of no effect, which is large enough to even sub-paramount the clear cases that have been given in the present case.
Does the fact that the Hague Rules apply through private agreement of the parties, does that fact change your argument in terms of the rules having the force of law?
I completely agree, Mr. Arbitrator, that when it comes to contract, when it's incorporated contractually, we need to look at the contract in a whole and see the other clauses as well. However, the only argument that I would like to place in this regard is, if the intention of the parties was to exclude the liability clauses under the Hague Rules, they should have done so explicitly. By excluding Article 3, Rule 8, by excluding Article 4, Rule 5 of the Hague Rules, they should have done so explicitly, which has not been done in the present case. And the parties themselves have consented for the whole contract to be subject to the Hague Rules. Thereby, we cannot draw any further inference as to whether Hague Rules should not be applied in total or not, because the intention of the parties to apply it in toto is very clear from the contract itself. Yes, sir.
So far as the researcher is concerned, I'm still trying to look for that paragraph which it says force of law. I've read the whole judgment, but I may have missed the point, but I can't find paragraph on the fact that it has the force of law. Simon, I don't know whether you found it.
I haven't. I'm a bit scared about trying to multitask in case I lose this Yatley thing. So I haven't. I mean, I know there's been a quotation of Article 3, Rule 8 has been given to us, but we haven't seen any quotation of the relevant paragraph in Saba, which would be quite helpful if we could get that.
Surely. Members of the tribunal, would you allow me to give the exact paragraph and the reading in my rebuttals? I would ensure that it comes to the members of the tribunal because I have 3 minutes left and I have one more submission to make.
Okay, yes, do
Very
the rebuttal.
Very grateful for your kindness. Now moving to my final submission, which is that clause is liable to the full amount as agreed under the Hague Rules. Firstly, it is to be seen that clause 3 is given clause paramountcy. And saving Article 9 from the said rules is not valid under Article 3, Rule 8, as it was also held in the case of the Rosa. Very similar factual matrix, and they agreed to 100 sterling per pound, and they left out Article 9, which says that 100 sterling per pound, as given in Article 4.5, should be subject to Article 9, which is the gold value. And the same judgment also held that such a limitation will be void in case of application of Article 3, Rule 8. Furthermore, the case of EPAR in the Singapore High Court judgment had clearly held that if there is any limitation which is lower than what is provided in the Hague Rules itself, that clause remains null and void at the face of it without any question. Now, my learned defendants may pose an argument that clause 11 of the Combicant Bill was rather deleted, which speaks about special provisions to liability and includes the Hague Rules by the way. We would like to place this argument before the tribunal that mere deletion of clause 11 does not imply the deletion of particular articles of the Hague Rules. It can also be a case that they wanted to avoid confusion, which is why they deleted clause 11. So we cannot decide on the intention of the parties for deletion of clause 11 of the Combicant.
One thing does strike me about your argument about the gold clause, which is certainly very intriguing.
Yes.
Would it be natural for any parties who agree on the sum of £100 sterling to be thinking in terms of gold value, given that no currency effectively has been based on gold now for about 60 years? Are you not very much going against what is likely to have been the intention of the parties?
Mr. Arbitrator, I understand your concern, and I would like to state that as per the Hague Rules, Article 4, Para 5, if the parties have subjected themselves to Hague Rules 1924, they would have very well been aware that the entire convention only deals in terms of gold value. And I'm also aware of the fact that there was a gold clause agreement that was signed in the UK, which raised the amount to 400 sterlings, but even that was not agreed upon here. Thereby, the only agreed thing that we can see by the addendum is the subjection to the Hague Rules and paramountcy which is given. Once paramountcy is given, saving Article 9 from the said rules shall not apply because that was exactly the judgment which was given in the Rosa as well. I hope that answers your question, Mr. Arbitrator.
It certainly explains your point of view. I think you may have a little persuading to do, but you've explained your point of view extremely well. Thank you.
Thank you so much for your kind and patient hearing. Now I would pave way for the defendant counsel. It was an honor arguing before this arbitral tribunal, and I will surely get back to the relevant para in the rebuttal.
Thank you so much.
A very good evening, panel. If I may confirm whether I'm audible and visible.
Yes, you are very audible and very visible, and it is a great pleasure.
Thank you so much, Arbitrator. It's a great pleasure as well. May it please the arbitral tribunal. I'll begin with the submissions. The timer hasn't been started.
I'm sure the host is about to press the button now.
Right, I'll begin.
It hasn't actually been started. It's stuck on 21 minutes at the moment, so I think it needs to be started.
It will start when I begin, maybe.
Let's see.
May it please the arbitral tribunal.
Yeah.
This is the counsel appearing on behalf of the defendants, Taway Private Limited and Cruise SA. I will be speaking first for 21 minutes, and my co-counsel would speak next for another 22 minutes. The counsel would first be addressing the procedural issue at hand, which pertains to the number of arbitrators that should preside the arbitration proceeding, and would secondly address the merits of the substantive issues. Arbitrators, the defendant's first contention is that the arbitration proceeding should be presided by a sole arbitrator. In pursuant to this, the counsel would be putting forth a two-pronged submission. Firstly, that the International Arbitration Act of Singapore is applicable to the present proceedings, and consequently, Section 9 of the IAA shall prevail over Rule 8.2 of the SCMA rules. Moving ahead with my first submission, panel, we would like to draw your attention to page 3 of the case study. Now, under clause 1 of the issued bill of ladings, parties adopted the SCMA rules of arbitration. Rule 32.1 of the said rules clearly stated that unless otherwise agreed by the parties, the seat of arbitration shall be Singapore, and where the seat of arbitration is Singapore, the International Arbitration Act of Singapore shall apply. Placing reliance on the said rule, we submit that in the instant case, IAA shall be applicable to the arbitration proceedings, as no alternative seat of arbitration has been chosen by the parties. The counsel would now like to draw the attention of the tribunal to Rule 2.1 of the SCMA rules. Now, the said rule states that if the adopted rules are in derogation to any mandatory provision of the law of the seat, which in the present case is IAA, then in such case, such applicable law shall prevail. This brings me to my second submission, where we submit that Section 9 of the IAA is a mandatory provision, and consequently, it shall prevail over Rule 8.2 of the SCMA rules.
Counsel, can we just, I'm just looking at Section 9 of the IAA. It says if the number of arbitrators is not determined by the parties, there is to be a single arbitrator. So bearing in mind the qualification there, if the number is not determined, I have difficulty seeing why you say it is a mandatory provision.
Mr. Arbitrator, it is a mandatory provision because this very Section 9, it recently got amended in 2020. But before 2020, the provision read as, if the number has not been determined by the parties, there shall be a single arbitrator. The usage of the term shall gives it a mandatory effect.
But counsel, the arbitration was started in 2021.
Indeed, Mr. Arbitrator. The council very much acknowledges the fact that now the wording has been changed to is to instead of shall. However,
why are we interested in pre-2020 when the arbitration was started in 2021?
Arbitrator, we are interested in pre-2020 because Right here, we are trying to understand the intention of the legislature. And
But isn't
when
it, why is the intention of legislature important? It's at the date of invocation. What is the law which is applicable?
indeed, Mr.
How is the
Arbitrator,
intention of the legislature? We're not in a writ jurisdiction or a judicial review challenging the act or something. We're here, the claimants have invoked arbitration as per the terms of the arbitration clause, and we have to look at the act and the rules which they have agreed to apply and understand whether it will be a tribunal of 3 or 1. What the
Indeed.
history was prior to 2020 is irrelevant. What is the law today is relevant.
Indeed, Mr. Arbitrator. The council would answer it by putting forth two submissions. First of all, we are going into the intention of the legislature because the Singaporean legislature doesn't explicitly differentiate between mandatory and non-mandatory provision, and therefore the council is going into the construction of the specific provision, and that is why it is very important for us to be aware of the intention with which the specific provision was constructed. And secondly, arbitrator, we are saying that when shall was replaced with the term is to, the Singapore ministry very much clarified in a press statement that this replacement is being done just for the convenience for the Singaporean people because they got done with the archaic words. However, with this, the council just wants to bring this to the panel's attention that the value of the shall still holds true, and hence it should be considered to be a mandatory provision.
But shall can be a discretionary provision as well.
Arbitrator, usually when the legislature incorporates the word shall, that means that it intended to give it a mandatory effect. And in fact, this has been agreed by the claimants themselves in their submissions on para 13, page 21 of the memo that they submitted, that to quote their submission, they have written that section 9 does not mention the term shall, which is an essential for it to be a mandatory clause. That clearly implies that they agree that by usage of the term shall, the clause would become a mandatory clause. And furthermore, to add on to this, the council would also take the aid of model law, where articles such as 33 subsection 1, which apply in the absence of an agreement, just like section 9 of the IAA, they are considered to be mandatory provisions. And hence, we are putting this forward that section 9 should be considered to be a mandatory provision, and therefore rule 8.2 should be allowed to prevail over it.
I'm a little bit interested, if I can say so, in why the Singapore legislature should have wanted to make it so difficult to choose more than one arbitrator. I can see why a provision should be construed as mandatory if it deals with the fairness of the arbitration or something like that. But it seems a little bit odd that a matter such as the number of arbitrators should not simply be left up to whatever this tribunal considers the intention of the parties.
Arbitrator, when we are talking about section 9, it says that a sole arbitrator should be appointed, which is actually different from what has been given in model law, which has been given the force of law in Singapore. Model law says that 3 arbitrators should be appointed, and IA says that a sole arbitrator should be appointed. Yeah. This different position that the Singaporean legislature has taken in its statute, again, points towards their intention that they wanted to determine the number of arbitrators in case the parties have not come up with an explicit agreement between them.
So if I may just take on from Ms. Teo's what he's suggesting, if you just come back to section 9, it says if the number of arbitrators is not determined by the parties, the word is determined by the parties. Now, the parties have agreed to incorporate the SCMA, which provides that if the numbers, if there is a silence as to the numbers, then it will be 3 arbitrators. So haven't the parties, by accepting the SCMA rules, determined that having not specified the number of arbitrators, it will be 3. And therefore, by virtue of that, Section 9 will not apply to have a sole arbitrator.
Mr. Arbitrator.
Consistency on that.
Mr. Arbitrator, again, I would
No,
like
inconsistent to have an arbitration of 3, a tribunal of 3.
Sorry, Arbitrator, I couldn't gather the last question.
The Act does not say that you can't have 3 arbitrators or 4 arbitrators. So it's not. I don't think it's inconsistent with the Act. So what's wrong in having agreed to the SCMA rules, which allow you to have 3 arbitrators, to have 3 arbitrators?
Panel, however, the parties haven't determined a specific number of arbitrators in their agreement. They've just resorted to SCMA rules. And in fact, do I sense a concern, arbitrator?
See, the 2 wordings are very important. If you read Section 9 of the International Arbitration Act, it says, if the number of arbitrators is not determined by the parties. Whereas in SCMA, it says where parties have not agreed on the number of arbitrators, but have agreed to the rules, 3 arbitrators shall be appointed. So according to me, the parties have determined through the SCMA, by being quiet on the number of arbitrators, that they have determined a tribunal of 3. And once they have determined a tribunal of 3 by virtue of having accepted the SCMA, the sole arbitrator would not apply. Would that not be correct?
Mr. Arbitrator, Section 9 of the IAA also provides for a default provision that a sole arbitrator should be appointed. And Rule 8.2 also provides for a default provision that in case there is no agreement, then 3 arbitrators should be appointed. And when there is an apparent inconsistency between both the provisions. And this is the time when we'll take aid of Rule 2.1, which says that if the rules in the IAA, they are in derogation to each other, we would then resort to seeing whether Section 9 is a mandatory and non-mandatory provision. And hence, as has been established by the Council that Section 9 should be considered as a mandatory provision, it should be allowed to prevail over the Rule 8.2. This is what our position is. Moving ahead with my submission, the Council would now like to cite the case of Dharmajaya Properties versus Premium Properties, which has been given on page 4 of the PDF of the compendium. The parties in the instant case had adopted the arbitration rules. Now, under the rules, there was no provision for arbitrator to have the power to award security for costs. However, under the IAA, the arbitrator had such power. And the court held that the specification of rules does not oust the application of IAA, and hence International Arbitration Act of Singapore was allowed to prevail over the adopted rules. And applying the similar ratio or the logic, it is humbly contended that in the instant case also, IAA should be allowed to prevail over the adopted SCMA rules. Now, moving ahead with my next submission, the Council would now be proving that the incorporated Hague rules don't have any force of law. Firstly, the Council would address that which set of Hague rules govern the issued bill of ladings. And secondly, it is contended that the incorporated Hague rules don't have any force of law. Now, panel, there's no dispute among the parties that when we are talking about clause 4 of the issued bill of ladings, it refers to Hague Rules 1924. What we submit is that it cannot be contended by the applicants that since the bill of ladings have been subjected to English law, the parties have incorporated Hague-Visby rules. That is because none of the conditions prescribed for the application of the Hague-Visby rules have been satisfied. Article 10 of the Hague-Visby rules clearly states that for the respective rules to be applicable, the bill of lading should be issued in a contracting state, the carriage should be from a port in a contracting state, or the contract contained by the bill of lading must provide. Do I sense a concern, Mr. Arbitrator? Sorry,
I think hasn't this been accepted? Accepted by the other side, but I don't think they've been arguing for the Hague-Visby rules applying.
Apologies, Arbitrator. I couldn't gather the question. If you could please repeat it.
I don't think this point about the Hague-Visby rules is actually something which has been asserted by the other side.
In fact, they made a specific statement that it's the Hague rules which will apply, and the arbitrator asking.
Indeed, Mr. Arbitrator, our contention is that Hague Rules 1924 would be applicable and not Hague-Visby rules.
That's
yes,
fine.
and I believe the claimant's position is it is the Hague rules. So I don't think there's a dispute on this point, Counsel.
Indeed, moving to my second submission. Since there's no dispute on this condition, I'll move to the second submission. We contend that in the instant case, the incorporated Hague rules don't have any force of law. Now, panel, two statements were made in regard to the force of law by the applicants. Firstly, it was contended that the incorporated Hague Rules 1924 possess force of law, and they relied for the statement on the judgment Sabah Floor versus Feed Mills. And secondly, it was contended by the applicants that a contractual interpretation should be given and hence paramount effect. I would be addressing both of them. Firstly, addressing about the Hague Rules 1924 having force of law. Panel, the facts of the case Sabah Floor versus Feed Mills are very different from our case. In fact, in this very case, the specific clause incorporated by the parties was given precedence, was given priority over the clause incorporated the Hague Rules. This is first thing. And secondly, Sabah Floor nowhere says that the Hague Rules 1924, if they are incorporated into a contract, should have force of law. The applicability of Hague Rules 1924 has been provided in Article 10, which says that if the contracting state has rectified those very Hague Rules, then it would have force of law in UK. However, in this case, since Santos had not rectified Hague Rules 1924, they are not applicable. They don't have any mandatory effect. They don't have any statutory effect when they have been incorporated into this contract. Secondly,
they do have contractual
Can I
effect.
say, doesn't this leave it open, leave you open to the argument that the parties simply intended that Article 3, Rule 8 should rule and should overrule any exemption clause, any clause reducing the parties' liabilities below what is provided by the 1924 Hague Rules?
indeed, Mr. Arbitrator, the Council would now be addressing the contractual interpretation effect of incorporating the Hague Rules 1924.
Thank you.
Referring to the case of W.R. Varnish versus Kheti, in which it was held that when the Hague Rules are incorporated into a contract, they can be displaced by contrary clauses found elsewhere in the contract pursuant to general principles of contractual construction. Referring to the book Shipping Law, which has been authored by Professor Simon Bhagan, the arbitrator himself, that where there is a conflict between the provisions of the Hague Rules incorporated under a clause paramount, any conflict between their provisions and express terms of the contract should be resolved by reference to the ordinary contractual principles of construction without reference to Article 3, Rule 8. This is the exact line that I'm quoting from the book. Since in the given case, the rules have been incorporated voluntarily, this is our contention that they don't have any force of law. They must be construed in accordance with the rest of the contract. And even if we go for a contractual interpretation, the specific clauses in the contract would override the clause incorporating the Hague Rules. My co-counsel would be dealing with the specific versus general thing in greater detail. Yes, panel, before I summarize my submissions, if there are any questions.
Not for me.
No, I am certainly very grateful for what you said. It's been remarkably lucid. Very helpful.
Thank you, arbitrator. I'll summarize my submissions. In the present case, we contend that a sole arbitrator should be appointed because the International Arbitration Act of Singapore is applicable because it's the law of the sea. And Section 9, since it's a mandatory provision which can be derived from the wording of that very provision, it should be given an overriding effect over Rule 8.2 of the SCMA rules. Further, there's the Hague Rules incorporated into this clause don't have any force of law. And secondly, even if we go for a contractual interpretation, the specific clauses would override the general clause incorporating the Hague Rules. Thank you, panel. It was an honor arguing before the arbitrators.
Thank you.
Anil, before I start, I would just like to confirm if I'm properly visible and audible.
Yes.
Good evening. I am Himang Arora, the counsel for the second defendants and the first defendants. I will be presenting my contentions firstly by showing that the first defendants aren't liable and then be doing the same for the second defendants. With respect to the first defendants, the following roadmap or the order will be followed. Firstly, it will be shown that there is no application of Article 3, Rule 8 pursuant to Article 7 of the Hague Rules, which is a savings clause. Secondly, Clause 2 shall prevail over Clause 4 due to two reasons. Firstly, lex specialis, that is a special clause, shall prevail over a general clause. And secondly, due to the usage of express terms, a sufficient warning has been given. Thirdly, that Clause 2 shall prevail over Clause 9 because a typed clause is given preference over a printed clause. In arguendo, it will be argued that the maximum liability that can be affixed is $10,000 as per the party agreement pursuant to Clause 3 of the addendum. Proceeding with the first link, I would request my researcher to just enter Article 7 into the chat box for the reference of the honorable arbitrators. The Article 7, in essence, simply is a savings clause which states that nothing contained in the Hague Rules shall prevent parties from agreeing to a certain stipulation or exemption as to the responsibility and liability of the ship as well as the goods, and with respect to the goods, the care, custody, and handling prior to loading and subsequent to discharge from the ship from which the goods are carried by sea. Now, in this clause, I would like to bring attention to some very specific terms. It says that nothing herein contained, which is a savings clause. Secondly, it refers to an agreement, which in the present case is the Odysseus Bill of Lading. Thirdly, it states that the liability, it can be exempt the responsibility and the liability of the carrier, which is the first defendant in the present case. Fourthly, it says that subsequent to the discharge from the ship being Odysseus in the present case, and the goods being discharged from it. And lastly, it says that the goods are carried by sea. It doesn't mention the term port of discharge. It simply says discharge from the ship. Now, applying all these specific terms to the present case, I would request the arbitrators to look to the second clause of the case study, which has been referred to on page number 3 clause 3.2, it clearly says that once the goods are discharged from odysseus, all liability shall cease. And moreover, to counter any other interpretation, the two terms that can come into question are ship and carriage of goods. Ship has been defined as any vessel that is used for the carriage of goods by sea, which is odysseus. No question as to that. And secondly,
excuse me, can I stop you a moment there?
Indeed.
Why
indeed.
could the word ship not equally refer to the Hidalgo? Because the owners of the Odysseus agreed to carry the goods to Chennai. So surely ship here refers to any ship in which the goods are carried anywhere between Santos and Chennai.
Indeed.
That may be stupid on my part, but I think you have a bit of persuading to do.
Not at all. So the answer to this question is that party agreement is paramount, Mr. Arbitrator. Herein the parties, if intended to include Hidalgo or any ship post-transshipment, the parties would have mentioned it in clause 2. However, in this particular case, the parties have specifically mentioned discharging from Odysseus. Does that answer your question, Mr. Arbitrator?
I'm certainly much clearer as to the point you're making. Thank you very much indeed. That's very helpful.
Much obliged. Now, moving to the second limb of my arguments, it is argued that clause 2 is a very specific clause, whereas clause 4 is a general incorporation clause of the Hague Rules. Thus, in case any inconsistency arises, the special clause shall prevail as parties paid due regard with and had negotiations with respect to these specific type clauses. To support this submission, the council would like to refer to the case of Mary Fortuna Navera versus the government of Ceylon, which is a Queen's Bench decision and can be seen on page number 7 of the compendium. Herein, it was held that the tailor-made clause or the specific clause was prevailed over the general incorporation clause paramount, and it was held by the court that if any other interpretation would have been taken, the special clause would be of very little practical value. And it also held that the Hague Rules were incorporated so that they would remain to govern the whole other set of facts in the contract. Now, once clarifying the case that has been referred to by my co-counsel as well, even in the case of Warnish versus KP, it was held that if terms of sufficient warning are used in a clause, then it shall be assumed that the parties had paid sufficient attention to it. In this particular case, very express terms like whatsoever, any and all liability shall cease have been mentioned. Moving to the third limb, it is contended that clause 2 shall prevail over clause 9 as typed clauses prevail over printed clauses. To support this contention, the council would like to refer to the case of Satya Kailash, which can be seen on page number 8 of the compendium. In this case, a typed clause imposed absolute warranty of seaworthiness. The court held that this took priority over the usual or the general obligation of due diligence. And it should be noted that the Hague Rules were incorporated through a clause paramount in this particular case. Moreover, following the same principle, clause 2 says that there shall be no liability, whereas clause 9 says that the carrier shall be responsible for the acts and omissions of if the carrier employs a third person. There seems to be a conflict between them. Hence, the typed clause shall prevail. Moving to my fourth limb, it is argued that even in arguendo, even if it is contended that the first defendant shall be liable, the liability shall be affixed to a maximum of $500 per unit. That comes out to be a total of $10,000. Herein, the party agreement is to be given paramountcy, as has been agreed in all arbitration proceedings. And lastly, to further support this argument, clause 3 also gives us express warning, which says, in any circumstances, taking me back to the case of Warnish versus Kheti. Now, if there are no questions, I would like to move ahead with my contentions with respect to the second defendants. Seeing that no questions are there, the order that I will be following is, firstly, that the second defendants were exonerated from any liability pursuant to clause 15 of the Odysseus Bill of Lading. Secondly, that the second defendants can rely on the terms of sub-bailment, and Article 3, Rule 8 doesn't override such specific provisions. Lastly, it shall be proven that Article 9 was deleted by Hidalgo Bill of Lading with an intention that the liability or the limitation clause shall be treated separately. Servants, as per clause, it shall be brought to the attention of the arbitrators that as per clause 15 of the Odysseus Bill of Lading, the clause includes subcontractors, such as in the present case. And it is but obvious that a Himalaya clause is added to a bill of lading so as to exempt third parties, so as to give them benefit of it. In the Starson case, which can be referred to page number 9 of the memo, it was held that ship owners carrying goods on behalf of the original contracting carrier qualify as subcontractors for the purpose of Himalaya clause. In the present case, the goods were being carried from Santos to Chennai, and they were transshipped at the port of Cartagena. A substantial part of the goods were being carried by the second defendant. Hence, they qualify as subcontractors so as to take benefit of the Himalaya clause. Thus, reading clause 15A and B together, it makes it very clear that the intention of the contracting parties was that no liability shall attach to any servant, agent, or independent contractor employed by the contractual carrier, that is Tawai in the present case. And thus, the second defendants are entitled to claim exemption under clause 15B. Moving to
Counsel, can I just ask a question? Are you suggesting that the Starson doesn't cover this particular situation because crews are the second carrier, but they are a ship owner?
Mr. Arbitrator, I think I came across as wrong. The principle that I intended to highlight in the Starson case is that a second carrier transporting goods by carriage of sea qualifies as subcontractors. Thus, they shall come under the definition of servants or subcontractors under clause 15 of the Combicon Bill. Does that answer your question, Mr.?
Well, what about Article 3? What about Article 3, Rule 8? Won't that invalidate this Himalaya clause as regards somebody who is a sea carrier?
With respect to Article 3, Rule 8, it is contended by the second defendants is that firstly, in that case, it was held that the rules were the basis of the contract, and so they were applicable as force of law. In our case, we are arguing that the rules don't govern the contract as force of law and just have been incorporated voluntarily. Second, that the reasoning given in that case was not unanimous. Lord Steen's dissenting judgment was also considered to be very important. It is a contention that in the present case, the second defendants qualify as servants and can take exemption under clause 15 of the Odysseus Bill of Lading.
Okay, thank you, counsel.
Moving to the second limb, it shall be shown that the second defendants can rely on the terms of sub-bailment. When the owners transfer goods and they expressly or impliedly consent to sub-bailment, they shall be bound by the terms. This is the principle of the sub-bailment. This is the principle of bailment on terms of sub-bailment, as said in the Pioneer case. The Pioneer case can be referred to on page number 10 of the compendium. In the present case, it was stated that any transshipment can take place on any terms whatsoever. And if the transshipment, that is the Hidalgo Bill of Lading, a clause, a maximum liability was affixed, that is 1,000 pounds per sterling per package. That comes out to be around $27,600 in the present case. Thus, that is the maximum liability that can be affixed to the second defendant. Moving to my last limb of contentions, it should be very specifically noted that in the Hidalgo Bill of Lading, Article 9 of the Hague Rules were specifically deleted. Do I sense? I shall continue. It shall be noted that Article 9 was deleted by the Hidalgo Bill of Lading. Thus, it is contended that the intention of the parties was the liability clause shall be treated separately. To support this argument, the Council shall refer to the case of Tasman Discoverers, that is, Dairy Containers Limited versus Tasman Oriented, in which the Hague Rules were incorporated through a contractual provision, along with the limitation provision with respect to the quantum clause. It was held that the Hague Rules could be construed in accordance with the deeming limiting provision. In the present case, the purpose was to give Hague Rules different meaning, namely Article 4, Rule 5, as if it were unqualified by Article 9. In the Tasman Discoverer case, the Privy Council held that the express limitation stated by the parties altered the limitation aspect of the Hague Rules itself, and that the effect had to be given contractual purpose. If there are no further questions, the Council...
I have some further questions. Which limitation provisions are you relying on? In which bill of lading do those limitation provisions apply? Are they limitation provisions in the your own bill of lading, the cruise bill of lading, or the TAWI bill of lading?
The Council is relying on the Hidalgo Bill of Lading for this purpose.
Is that your own bill of lading?
Yeah, the bill of lading contracted between the first and the second defendants.
Right. Don't you have to make your mind up as to which set of terms you're going to rely on? Because you are, on your primary argument, you are relying on the Himalaya clause in the first bill of lading, and indeed. I recall Lord Gough in the Pioneer Container saying that you have to make your mind up and make a choice. And I think you seem to want to have it a bit of the first bill of lading to get you out of all liability, and then you want to rely on the terms of the second bill of lading, your own bill of lading, in respect of, if you are liable, what limitation of liability will apply. So what do you say to that?
Mr. Arbitrator, I agree that I am playing it safe. Firstly, my main argument is that the Himalaya clause shall apply. However, if the arbitral tribunal thinks otherwise, in arguendo, I'm not conceding, I'm just assuming if the arbitral tribunal, as to its own discretion, thinks otherwise, I'm giving my second argument that a maximum liability can be of $27,600.
Thank you. That is just useful to have that clarified. Thank you.
Much obliged. If there are no further questions, I seek permission to read the prayer.
Pray away.
Thank you. Therefore, in light of the issues raised, arguments advanced, and authorities cited, the defendants humbly pray that this tribunal may be pleased to adjudge and declare that, firstly, that the tribunal shall consist of a sole arbitrator. Secondly, that neither Hague Rules or Hague-Visby rules are applicable by operation of law. Thirdly, that TAWI is entitled to rely on Clause 2 of the addendum to the Odysseus Bill of Lading and is exonerated from any liability towards the claimant. Fourthly, in any case, TAWI is entitled to limit its liability to a total amount of $10,000. Fifthly, that cruise is exempted from any liability by virtue of the Himalaya clause, that is Clause 15 of the Odysseus Bill of Lading. Alternatively, that cruise is entitled to limit its liability to a total amount of $27,600, award costs in favor of the defendants, and or pass any other order that this tribunal may deem fit in the interest of justice, equity, and good conscience. It was an honor arguing before this arbitral tribunal. Thank you.
Thank you.
Thank you very much indeed.
Greetings once again, panel of arbitrators. I would begin with my rebuttal with your permission.
Yeah.
My apologies, my rebuttals with your permission.
Yes.
First of all, I would go, I understand that there's a lot of tension in our room with regards to the Sabah floor case and what exactly it says. So I would like to request this arbitral tribunal to move to page 679 of the compendium which is submitted, the PDF page 679 and 675. Simon sir, I would be reading it out as well to avoid inconvenience to you. I'm just going to summarize what exactly happened in the Sabah floor case. The Sabah floor case had a clause 23, which was side noted as exceptions. And under the exceptions, there were certain articles of the Hague Rules in itself that were given, along with an exceptional clause that except clause 8 thereof of Article 3 was provided. So this was the matter that came before the court, and what was held in the particular case, if I may read, clause 23 of the exceptions read that Article 3, except clause 8 thereof, Article 4, Article 7, and Article 9 of the schedule of the Carriage of Sea Goods Act of the Australian Act will apply to this charter party and shall be deemed to be inserted in extenso herein. This charter party shall be deemed to be a contract, and no regard shall be had to Article 1 of the said schedule. Nothing in this clause shall be deemed to be prejudice or limit clauses. The specifications were given. The reason as to why the claimants relied on this particular case is to prove that in order to exclude a particular article of the Hague Rule, there needs to be express mention. And the same has been given in the same case as well.
Just pausing you there. That
Yes.
was not the reason that this case was relied upon. What was relied upon by the claimants,
The force
was
of law.
the case of the proposition that the rules have the force of law.
Indeed, sir. That is our contention on the basis of this judgment, which I would come to. The fact that...
If you could come directly to tell us where in this judgment does that say that? That would be very helpful. That would cut
So
a
the
lot of...
I completely understand your concern. The judgment does not directly say that the Hague Rules will have the force of law. However, the understanding of the judgment will drive us to the conclusion that Hague Rules will prevail if there is no explicit exclusion. Because in the present case, there was an explicit exclusion, which is why the clause prevailed over the Hague Rules.
It might be quite helpful, counsel, if you could actually read out paragraph 10 of the judgment.
Yes, sir.
Because that's what you referred, or,
Yes.
or either you or your co-counsel referred to, and what we still haven't had the chance to look at that.
Clause 10 reads as follows.
No, paragraph 10. Paragraph 10.
I'm sorry.
Paragraph 10 of the judgment, which is the relevant
Paragraph
one.
10 reads as follows. The clause, whatever its precise ambit, plainly gives the clause in any contract an edge over the clauses of any other contract. And that was excluded. And it might be said that exclusion of that clause was specifically designed to ensure that the other clauses of the contract, if in conflict, would prevail.
Right, thank you. That has been helpful. Nothing to do with force of law, but more to do with
Yes, there is
contractual construction.
Not
Yeah.
directly to do with the force of law. However, the judgment, the whole judgment, if read in entirety, will let us come to a conclusion that if there is an explicit clause, of course, Hague Rules can be avoided, but when there is no explicit exclusion of a provision of Hague Rules, that will be incorporated in total. If I may move on, I realize that my time has lapsed. Can I please get 1 minute extension to just sum up
Yes,
all
1
other...
minute. 1 minute. Let's have that.
Yes, definitely, panel of arbitrators. Firstly, the UK Arbitration Act 1996 has the same provision in section 15 subclause 3, the same as to what is given in section 9, and the schedule of the UK Act itself says that section 15.3 is non-mandatory. My second submission is that my learned friend claimed that Tave is not liable after discharge from ODISIF. The intent of the parties was to make him not liable after discharge, which we completely agree. But the discharge should not have happened before they reached the port Chennai. And additionally, Tave was also the consignee in the Hidalgo bill of lading. A consignee is a person who's supposed to receive the goods. So he also has an obligation under the Hidalgo bill of lading to receive the goods. And according to this, we can picture that they wanted to receive the goods from Cruise and give it back to us because their actual port of discharge was Chennai. Therefore, Tave will be liable. Thirdly, my learned friend, my time has lapsed, so I would like to submit right away. All my other arguments are given in the written submissions. A prayer and relief sought is also given. If the arbitral tribunal may be kind enough to award 600,000 million as damages, we would be duty bound and we would pray. And also please award the cost and interest in the favor of claimant, as we've taken a lot of pain and effort to argue the matter before this tribunal.
Thank you. That was very helpful and extremely clear.
Yes.
Thank you.